Hello, my name is Julianne and I will be covering the case of R.V. Brown. The facts of this case are that Matthew Brown was a university student with no criminal record prior to this incident. At a party in Calgary, he consumed alcohol and large amounts of magic mushrooms. These mushrooms contain psilocybin, which causes delirium. While intoxicated, he broke into the house of an unknown individual and violently assaulted Janet Hamnen with a broomstick, caused permanent injuries. He then broke into another house and was found naked, confused, and injured by the police. During trial, he claimed that he was intoxicated to the point of automatism, which means that his actions were unintentional and involuntary. The issues are Section 7 and Section 11D of the Charter violated by Section 33(1) of the Criminal Code, which forbids the defense of extreme self-induced intoxication for some violent offenses. If so, is Section 1 sufficient justification for it? The holding. The Supreme Court of Canada ruled Section 33(1) to be unconstitutional because it violates both Section 7 and Section 11D of the Charter. This violation cannot be justified under Section 1 of the Charter. Ratio. Section 33(1) subsection 1 of the Criminal Code of Canada states that any person who, by any reason of self-induced extreme intoxication, lacks the general intent or voluntariness ordinarily required to commit an offense, nonetheless commits the offense if A. all the other elements of the offense are present, and B. before they were in a state of extreme intoxication, they departed markedly from the standard of care expected of a reasonable person in the circumstances with respect to the consumption of intoxicating substances. In short, Section 33(1) subsection 1 of the Canadian Code of Canada states that someone can still be found guilty if they harmed another person while intoxicated, even if they had no intention of doing it or lacked volition, provided that they were criminally negligent in becoming that intoxicated. However, Section 33(1) of the Criminal Code of Canada violated Section 11D of the Charter. This section states that any person charged with an offense has the right to be presumed innocent until proven guilty according to law in a fair and public hearing by an independent and impartial tribunal. Therefore, the Crown must prove actus reus, which is the physical act of conduct that constitutes the crime, and mens rea, which is the guilty mind during the act. Lastly, both mens rea and actus reus must be proven beyond a reasonable doubt. Section states that you cannot assume guilt based on an act that was unrelated to the actual crime. In this situation, it involves drinking or doing drugs beforehand. According to Section 33(1), the court can convict someone even if they did not have a guilty mind during the time of the crime, and it does not matter whether or not their actions were voluntary. This is a shift between the burden of proof because the Crown no longer has to prove guilt, and the accused must now prove their innocence. So rather than being presumed innocent until proven guilty, the accused is already presumed guilty just for being intoxicated. Section 11D of the Charter guarantees the presumption of innocence and the right not to be convicted unless proven beyond a reasonable doubt. Therefore, Section 33(1) violated Section 11D of the Charter. I saved Section 7 of the Charter for last because this is what I will be focusing on for the majority of my presentation. This section states that everyone has the right to life, liberty, and security of the person and the right not to be deprived thereof, except in accordance with the principles of fundamental justice. This section ensures that people cannot be imprisoned, punished, or harmed by the government unless if it follows basic legal fairness. One of those fundamental principles is that punishment should only be meted out for the intentional and voluntary actions. What counts as voluntary is if someone consciously chooses to partake in the act. Therefore, it does not count as voluntary if someone is in a state of automatism. Examples of these states include sleepwalking, unconsciousness, or delirious states. Therefore, if the person's body is moving without their control, they are not guilty because they did not choose for their body to act this way, making the act involuntary. Again, Canadian law requires both actus reus and mens reus for the person to be criminally responsible. If the individual lacks volition, then there is no actus reus because their body acted without their control. Similar to the scenario in Section 11D of the Charter, Section 33.1 of the Canadian Criminal Code violated Section 7 of the Charter by removing the voluntary requirement when they stated that someone can be found guilty if they harmed another person while intoxicated, even if they had no intention of doing it or lacked volition, provided that they are criminally negligent in becoming that intoxicated. This undermines a key principle for fundamental justice because the law cannot criminalize people for involuntary behavior. By doing so, they are punishing the morally innocent whom the Charter is meant to protect. Section 1 of the Charter, it guarantees the rights and freedoms set out in its subject only to such reasonable limits prescribed by law as can be demonstrably justified in free and democratic society. This means that if the rights of an individual had been violated by the law, then the court will apply the Oakes test. First, this test asks if there is a pressing and substantial goal. In this case, Section 33.1 had the goal of protecting victims of crime and to ensure that people are held accountable even during intoxication. Secondly, it asks whether Section 33.1 is rationally connected to its goal. In this case, it is because the goal is to discourage people from consuming intoxicants that might cause them to lose control and become violent. It also claims to hold them accountable even if they lose voluntary control. However, the problem came in the next steps because it did not impair the rights as little as possible and the benefits do not outweigh the harm. Section 33.1 can easily catch innocent people because people who are truly experiencing a state of automatism are punished, even if their actions were involuntary. Although this section is meant to promote safety and accountability, by convicting someone who did not commit the act voluntarily, it can harm the justice system. Steps of the Oakes test must be satisfied for a charter violation to be justified under Section 1 of the Charter. Therefore, this violation is not justified. According to Section 7, an individual cannot be deprived of their rights to life, liberty, and security, and not to be deprived thereof except in accordance with the principles of fundamental justice. But what are these principles of fundamental justice? These are rules that ensure the government's laws are not unfair, vague, or too harsh. To be considered a principle of fundamental justice, it must meet 3 criteria. First, it must be part of the legal system rather than public opinion or morality. Second, it must be clear enough for courts to apply. Third, it must be a fundamental component of Canadian justice. Other examples include gross disproportionality, which is when the punishment is out of line with the seriousness of the offense. Voluntariness, which is when someone is being punished for involuntary actions. Diminished responsibility of youth, which is when the law treats young differently because they may be less blameworthy. And the right to due process or fair trial, which is when everyone deserves a fair chance at defending themselves at court. These are 3 principles that courts commonly accept in Section 7 cases. Arbitrariness. This is when the law lacks a logical connection with its goal. Overbreadth. This is when people are being punished more than necessary. Vagueness. This is when the law lacks a clear definition. Focusing on Section 7 of the Charter, we learned in lecture that there is a 2-step test for Section 7 violations. First, we must demonstrate right to any or all life, liberty, or security of the person has been deprived by law or government action. As long as the claimant can prove one, it is sufficient. Additionally, there must be a strong causal link between harm and government action. In this case, Mr. Brown was deprived of both his liberty and security. Section 33.1 of the Criminal Code allowed for conviction without actus reus or mens reus, which are both essential to bodily liberty and criminal culpability. There was a significant causal connection between the law, aka Section 33.1, and the deprivation of rights due to Mr. Brown's actions while in an involuntary psychotic state as a result of self-induced intoxication. Therefore, the first step of Section 7 test had been satisfied. Second step of Section 7 test requires for the claimant to prove that this deprivation is not in accordance with principles of fundamental justice. To do this, we must identify the principles of justice and establish that the principle is breached by the deprivation of the right. An example of a principle of fundamental justice is the fact that no one should be convicted for involuntary actions. However, Section 33.1 violated the actus reus requirement by stating that Mr. Brown is guilty of the crime, even if his actions were involuntary. Another example is that fundamental justice requires at least penal negligence. This asks if the accused's conduct represents a marked departure from what a reasonable person would do in the circumstance, not foresee any risk, and had no control over their actions. Lastly, Section 33.1 was too broad because it applied to all cases of severe self-induced intoxication, including unexpected reactions to substances. This makes it easier to convict innocent people who committed crimes without ill intent. Because both steps of the test were satisfied, we have proven that there has been a violation to Section 7 of the Charter. Case studies. The first one is Canada versus Bedford. In this case, 3 sex workers in Ontario, Terry Jean Bedford, Amy Levovichum, and Valerie Scott, launched a constitutional challenge against 3 criminal code provisions. First, the Body House Law, which bans them from working indoors. Second, the Living Off the Avails Law was meant to target parties and often misused against supportive individuals. Third, communication laws, which banned discussions regarding services in public. These laws made working conditions unsafe for sex workers because they were forced to work in isolated areas where assaults were frequent. To make matters worse, police responded in dismissive manners and often blamed the sex workers or ignored them completely. Evidently, these conditions violated Section 7 of the Charter because it threatens the security of sex workers. The deprivation was not consistent with fundamental justice because the laws were overbroad. Initially, the government had created prostitution laws to protect the public. However, these laws also applied to sex workers who were operating in safe conditions. They were not harming anybody, but were still criminalized. Therefore, the laws were broader than necessary. These laws were also grossly disproportionate because the sex workers were forced to work in unsafe conditions, which is out of proportion to the goal of keeping streets safe. Fortunately, the court found that these laws violated Section 7 and struck them down. My second case study is Carter v. Canada. This case challenged the absolute prohibition on physician-assisted dying under the Criminal Code. The plaintiffs argued that the law violated both Sections 7 and 15 of the Charter. For context, Section 15 ensures the right to equality, especially for the elderly or those with physical disabilities. It violated Section 15, but I will explain whether it violated Section 7 as well. But before that, I want to preface this by explaining the case that came before this, of Sue Rodriguez, which occurred in 1993. Sue was terminally ill with ALS and wanted to end her life when it was time. However, the court voted 5 against medical assistance in dying, whereas 4 supported it. The majority argued that although the ban violated security, this was still justified to protect the vulnerable. Moving back to Carter's case, the rights that were affected under Section 7 were life, liberty, and security because some people may choose to pass away and no longer suffer. However, these individuals could not make decisions regarding their bodily integrity and end-of-life care. These deprivations were not consistent with fundamental justice because the laws were overbroad. This meant that it blocked everyone from accessing assisted dying even if they were not vulnerable. It also denied autonomous adults from making decisions regarding their own death. Additionally, the law was arbitrary. This resulted in the Parliament passing Canada's Medical Assistance in Dying Law and the reversing of the Rodriguez case. What these 2 case studies have in common with R.V. Brown is that they violated principles of fundamental justice, dealt with laws that harm vulnerable groups. They all failed the Oakes test, and the Supreme Court declared that the challenged laws were unconstitutional. Connecting Module 8 to a current event. Unfortunately, the title of the article is disheartening to see for many vulnerable populations across Canada. In this case, Leon Jamal Daniel Barrett, a BC man, consumed both magic mushrooms and cannabis. As a result, he experienced a psychotic episode and attacked a stranger. He pulled her down to the ground in an attempt to remove her pants while sticking his tongue in her mouth. Fortunately, she was able to escape from biting his tongue as hard as she could. After the attack, he went home and stabbed himself in the chest because he believed that he had to reincarnate to save the world. Then he went out again to look for the actual woman that God had chosen. Police apprehended him in the street and he was charged with sexual assault, break and enter, and obstruction of a police officer. Although people may consider this to be an act as a result of mental disorder, Judge Hinkson wrote, "I am satisfied that the automatism was not caused by mental disorder. Furthermore, it was caused by an external cause, being the ingestion of magic mushrooms, boosted by the use of cannabis. Barrett was therefore acquitted for all charges." Now I have 2 discussion questions for everybody. First, do you agree that Section 7 of the Charter is violated when someone is convicted without evidence of actus reus? Why or why not? Second, if you personally knew the victim in cases like R.V. Brown and Leon Jamal Daniel Barrett, how will you feel about the accused being acquitted due to automatism? Moreover, is this emotional response appropriate in legal analysis? Thank you.